Good afternoon, friends. As those who have been connected with Beyond Law CLC, they know that the entire endeavor is to the effect that one should call persons who can help us to spreading the knowledge. The entire motto is that sharing is caring, and sharing is caring could also be stimulated by the thought process. And once you have a speaker of the immense knowledge like Mr. Milind Sathe, and as we were sharing, that his academics speaks a very unconventional mix that you find that it contains science, finance and arts, journalism, social services, and business management. In the ordinary course, one could just get the flip that it is just like a rolling stone carries no mosses. But here is a person who has different spectrums of knowledge, but at the same time having a knowledge on all spheres. And another fact that to be the president for the 2 terms, before we are coming live, I was asking him, like in Punjab Haryana High Court, we have the term of 1 year. They have the terms for 3 years because they also have a strong feeling that one person like Mr. Milind comes as the president. So it should be a strong, stable government where we all know, at least in the Bar Association, we don't have what we see in the today's era of defection, etc. And when the president is strong, the bar moves smoothly. And another fascinating fact which I observed during all these lockdown times, that the Bombay Bar Association is quite active towards disseminating knowledges. Through the Bombay Bar Association, you would find, and in fact, amongst us, we have Justice Roshan Dalvi. And at that point of time, I had shared with her that we had connected with her once we were seeing from the Bombay Bar Association, from struggle to success part. And we can say that struggle to success series launched by the Bombay Bar Association has helped us to connect with the persons who actually, as I said, stimulate the thought process, especially during these testing times, because once you get knowledge from a person who is having immense knowledge, it itself gives you a process to learn and to do better. And learning is not only by yearning, and yearning can only be once you have a person who gives the right directions. And today's topic, what Dr. Milind Sathe, president of the Bombay Bar Association, is to talk of law of writs. As a student of law and lawyers, we all know that the powers under the writ are immense. And to understand that writs within a short span, a person with immense knowledge can give in a capsule, which we are know the fact that it would be obviously there. Though in the lighter vein, they always say that as a lawyer, if you're strong on facts, argue on facts. If you're strong on law, argue on law. But if nothing, then writs. But that was all in the lighter vein. But writs have actually developed the law in a different perspective. Without taking much time, I acknowledge Justice Roshan Dalvi is joining us on the platform. Before we request Justice Milind Sathe, a short, I'll say, ma'am, to introduce Justice Dr. Milind Sathe in her own style, because she's also an erudite speaker and a person with immense knowledge. Over to you, Justice Roshan Dalvi, and then we will request Dr. Milind Sathe.
Good afternoon. The fact that I introduced Milind Sathe to you as my friend, as the advocate in my court, must be enough. At one time, when I had said about one junior lawyer to another judge that he's a very good lawyer, the judge called him in the party when I met him socially and said, if she says you are good, you must celebrate. So I think Milind Sathe must celebrate because he's the only one whom I've recommended so far.
I will just, before talking to Dr. Milind Sathe, I'm just reminding of the ad. It says, "Sirf naam hi kafi," and that is what the ma'am has said in a short form. Over to you, sir.
Thank you. Good afternoon, everybody. And thank you for inviting me to share my thoughts on a very topical, important subject, and particularly very, very dear to all lawyer fraternity practicing in the High Courts and Supreme Court. That is the topic of law of writs. I'm going to encapsulate the subject, law of writs, and then we will have question answers if there are any question answers at the end of the session. The concept of writ has originated in UK in 13th century. Writ basically means a written command or an order issued by a sovereign, a king, or a court, or an authority who can enforce that order, which is issued to subordinates, to the subjects, or to the litigants or other parties for obeying that order. And that order is to do something or forbear from something. Now, this concept of writ originated immediately after the Magna Carta in the 13th century, because Magna Carta was the first document which recognized rights of individuals against the state, that the individuals have certain rights. And for enforcement of those rights, a writ could be issued by the king or by the courts. Now, there are different kinds of writs. What we understand generally under the Constitution are known as prerogative writs. As against that, we have writs of course or writs of rights, which are issued by the courts or by that authority for asking. In the sense, you go comply with the formalities and you get that writ of course or writ of right issued. Prerogative writ is so called because it is the prerogative of a king or the court to issue or not to issue it. As we'll discuss little later, even if a petitioner establishes his right, it is up to the court to issue the writ or not to issue the writ, because it is the prerogative of the court, it is discretion of the court, and court weighs the justice of the case, other circumstances, and even if a party has made a case for issuance of the writ, court may not necessarily issue the writ, because if the other circumstances outweigh the possibility or the requirements of not issuing the writs. So that's why I call it is a high prerogative writ. As I mentioned, the writ concept originated in the 13th century, but in India, the concept of writ began in the 18th century in 1773, when the Regulating Act was passed by British Parliament, under which the Supreme Court of Calcutta was established in 1771. Similarly, two more Supreme Courts were established in 1800 and 1823 in Madras and Bombay, and these three courts had jurisdiction to issue writs under the Regulating Act. Now, these writs basically were two writs, writs of mandamus and writ of prohibition. These were the only two writs which were then known. Then in 1861, when the high courts were established under the Indian High Courts Act, the three high courts were established at Bombay, Madras, and Calcutta. They replaced the Supreme Courts which were functioning till then in these three presidencies, and the high court started functioning. So under Indian High Courts Act, also these three chartered high courts had jurisdiction to issue the writs. Then 1877, a specific relief act was passed by the British Parliament, which had virtually a provision of issuance of writ of mandamus. And that was section 45 of the Specific Relief Act of 1877. That act virtually provided what we consider as a writ of mandamus and the requirements of mandamus, which is you must have a legal right. There is an infringement of that right by another person, and then you can approach the court if you have no other legal remedy. And then court will issue that remedy, court will issue that injunction by way of a mandamus if there is justice in your case. So that was the actual provision in the Specific Relief Act of 1877. Those similar provisions continued in 1935 Government of India Act, which conferred the same powers upon the high courts. And then finally, we evolved the concept of writs which we practice today under the Indian Constitution, and two basic articles which we need to consider. Article 32 of the Constitution, which relates to the powers of the Supreme Court to issue writs, and Article 226 to issue writs by the high courts. There is another article which is not actually the writ jurisdiction, that is Article 227, which is a power of a high courts of superintendence over subordinate courts. That I will briefly touch upon. But these are the two basic articles, that is Article 226 and Article 32, which confer upon the Supreme Court and the High Court's power to issue the writs. Now, there are 5 kinds of writs which are recognized under the Constitution. There were several other kinds of writs which were in existence prior to 1950. But they have become all redundant now. They are not any more practiced in our courts, not anymore issued by the courts. The 5 writs which are issued, which we will discuss, are the writ of Habeas Corpus, writ of Mandamus, writ of Certiorari, writ of Quo Warranto, and writ of Prohibition. These are the 5 writs which are issued by the High Courts and the Supreme Court. And Article 32 and 226, they provide that the High Court and the Supreme Court may issue a writ in the nature of any of these writs which is suitable for a particular situation. So these are the 5 kinds of writs which are issued. Now, why this jurisdiction is necessary in the Indian context, particularly post-constitution? There are 2 or 3 reasons. One is, India has been declared under the constitution as a sovereign, socialist, secular, democratic republic. So it is basically a welfare state. And the duties of the state, what state is supposed to enshrine and ensure for its citizens, is embodied in Part 4 of the Constitution, which is Directive Principles of State Policy. As against that, there is a chapter on fundamental rights, that is Part 3 of the Constitution, which guarantees certain rights. Some rights are guaranteed to the citizens alone. Some rights are guaranteed to all persons who are within the territory of India. So there is a chapter on rights of citizens. As against that, the duties of the state or state's policies under the Part 4. So there is bound to be conflict. There is a welfare state. So state takes various measures for downtrodden, poor, etc. So somebody's rights are likely to be affected. While enforcing the fundamental rights, somebody else's rights may be affected. While implementing the directive principles of state policy, somebody's rights would be affected, particularly in concept of socialism. Though that concept was added in the 76 by way of 42nd Amendment, the seeds of socialism were already there in the Constitution, particularly 2 sub-articles of Article 39, that is Article 39B and C. Article 39B says that the state shall ensure its system is worked in such a way that there is no concentration of economic wealth in few hands, and that the material resources of the community are so distributed so as to subserve the common good. That's the concept of socialism, which is embodied in Article 39B and C. So when state takes a policy decision under 39B and C, somebody's rights are likely to be affected. So you have to strike a balance between fundamental rights and directive principles. Now, to ensure that, there has to be an independent arbiter. Now, that is the person, that is the judiciary, that's where the Supreme Court and the High Court step in by way of writ jurisdiction. So that's basically in a welfare state for the citizens or the persons to seek remedy, seek redressal if there is a state action against a particular person, if the person's rights are affected by the measures which the state takes while implementing its policies as a welfare state, as well as directing its policies under the directive principles of state policy. And that's why the necessity of the mechanism or the redressal method, which is provided under Article 32 as well as Article 226 of the Constitution. Article 32 itself is a fundamental right. Since Article 32 is in Part 3, it declares that right to move the Supreme Court for enforcement of fundamental rights is itself a fundamental right. So one can move the Supreme Court under Article 32 and seek any of the 5 writs which I mentioned. Similarly, under Article 226, one can move the High Court for the purposes of issuance of any of those 5 writs which I'm going to discuss now, and not only for enforcement of fundamental rights, but also for any other purpose. And that's where we will find that the jurisdiction of the High Courts for issuance of writs is much, much wider than that of the Supreme Court. While Supreme Court exercises writ jurisdiction under Article 32 only for enforcement of fundamental rights, the High Courts can issue writs not only for enforcement of fundamental rights, but also for any other purpose. And I will discuss what that any other purpose is. But the jurisdiction of the High Court is far, far wider, far more extensive than that of the Supreme Court under Article 32. Now, as I mentioned earlier, the 5 kinds of writs which are issued by the courts, and courts meaning both High Court as well as Supreme Court. The first and foremost is the writ of certiorari. Now, certiorari, as the original phrase means certification or correction. So for issuance of a writ of certiorari, there are 2 requirements. One is that there is an order passed by the subordinate authority. It could be subordinate administrative authority, quasi-judicial authority, or a judicial authority. So that is an order passed by that authority. That order, second, that order has affected a person's rights. There is a legal injury to that person, and that in such a case, a writ of certiorari can be sought. Now, so therefore, the basic necessity is that there is an order of a subordinate authority, and that order injures or infringes somebody's rights. So in that case, a writ of certiorari can be sought from the High Court. Now, there are various grounds on which a certiorari can be issued. The first and foremost is the manifest error of jurisdiction. Jurisdictional errors could be a variety of things. First and foremost, for exercise of a jurisdiction by a subordinate authority, jurisdictional facts must exist. If those facts do not exist, there is an inherent lack of jurisdiction. So that's the first ground on which a certiorari can be issued. Second is there is a manifest error of jurisdiction, either non-exercise of the jurisdiction or excess of jurisdiction, that the authority has lacks jurisdiction to exercise and pass that order, or it has exceeded its jurisdiction which it possesses, or there is a breach of principles of natural justice. And breach of principles of natural justice has variety of facets. As a student of administrative law, you all know that the natural justice includes a show cause notice, a reasonable opportunity of being heard, and also a reasoned order. So these are all grounds on which an order of a subordinate authority can be questioned in a writ of certiorari, that there is a violation of principles of natural justice, or the courts have evolved a manifest error on the face of record, leading the order to perversity. Now, this is very little subjective, but what particularly the judges and Justice Darvi would agree that what the judges look at is the justice of the case. And if the justice of the case is infringed or violated, then in that case, that is considered as perversity in that order. And on that basis, a certiorari could be issued. Now, there can be errors within jurisdiction. The writ court, while exercising writ of certiorari jurisdiction, will not sit as an appellate court over the subordinate authority. So that's a limitation on the exercise of writ jurisdiction. There is one Supreme Court judgment way back in 1954 in case of Hari Vishnu Kamath versus Union of India in 1954. That's a classic judgment on what a writ of certiorari means, when it can be issued, when it will not be issued, what are the limitations on issue of writ of certiorari, etc. That judgment of the Supreme Court of 1954 is still a valid Bible for the students of writ of certiorari. So if you have any doubt on what a writ of certiorari means, when it can be exercised, etc., limitations on that, is the judge answer to all that is the judgment of the Supreme Court in Hari Vishnu Kamath, is 1954 Supreme Court. That's the first writ which is issued by the Supreme Court. The second important writ which is issued by the Supreme Court and the High Court is writ of mandamus. Mandamus means a command. Mandamus to do something positive, or mandamus to forbear from doing something. Now, for mandamus, there are 2 or 3 essential requirements. A person seeking mandamus must have a legal right. Second, the person against whom he is seeking a mandamus must have legal obligation to perform towards the petitioner, that he is entitled for a discharge of that duty or that function from the respondent. So reciprocal legal right and legal duty to perform that obligation on the respondent. So that's the second requirement. The third requirement is that the person who is approaching the court has no other legal remedy. Now, of course, that is a requirement in the case of all writ petitions now, but that's a statutory requirement of a mandamus, as I mentioned earlier, even under the Specific Relief Act in 1877 and before that under the legislations. So if you have other remedy, you cannot...
May I make a request, sir? May I make a request? Sir, because I realized, because some students are there, one has only written, because I could gather, because I am a lawyer. They are saying slightly go slow because many students write notes also at the same time.
All right.
I can understand it's a normal routine as a lawyer. We also go in a seamlessly in a good flow. But for them, sometimes they feel that the notes are not being able to, though we will be uploading on the YouTube also. But be that as it may. Right, sir.
So, all right, I'll go back to the writ of mandamus. Mandamus basically means a command to do something or not to do something. For issuance of a writ of mandamus, when a person approaches the court, he must establish three things. One, that the person has a legal right to enforce against the respondent. Two, the respondent must have a reciprocal obligation towards the petitioner to perform his duty under the law. Three, that the petitioner must demand the compliance of his right and compliance of the duty of the respondent. And fourth, that the petitioner has no other remedy except to approach the court for issuance of writ of mandamus. These are the basic requirements for issuance of a writ of mandamus. So if there is something, some right has not been complied with by the other respondent, or there is an infringement of a right, there is a duty not complied with by the respondent, in such a situation, a person can approach seeking a writ of mandamus from the High Court or the Supreme Court. Now, since I have mentioned earlier writ of certiorari and writ of mandamus, in several cases, you will have an opportunity or you will have an occasion to seek both the writs. For example, there is an order passed by the municipal commissioner refusing to grant you license to carry on trade. So that order could be challenged in a writ petition, and you will seek a writ of certiorari to quash that order of the municipal commissioner. But that alone will not be sufficient justice for you. You will still need to get something more. That is, then you can seek a mandamus directing the municipal commissioner to decide your application for a grant of license and grant it in accordance with law. The court will not say it must be granted. Court will say it must be considered as long as you comply with all the requirements. So in a given case, you can ask for both a certiorari as well as mandamus. Now that's the second writ. The third writ, which also sometimes get coupled with this both writs, is the writ of prohibition. Now, writ of prohibition, there are 2 or 3 requirements. One is there is an authority under the statute or under the constitution or under any other enactment which is entitled to function. So there is an authority. 2, that authority is doing something in the sense it is exercising its jurisdiction to decide something. Decide something is a lease between the 2 parties, or deciding the rights and obligations of a person. So if that authority is deciding something, then you are related, or you have a locus in so far as that authority is concerned. So when you ask for a writ of prohibition, is if that authority is exercising that jurisdiction without having the jurisdiction, or doing something without jurisdiction, then in such a case, you can go to court and seek a writ of prohibition. The prohibition writ will be issued by the court if you demonstrate that the authority is acting in a manner without jurisdiction, or the authority does not have jurisdiction to do what it is proposing to do or what it has actually done. For example, I'll give an illustration. Municipal commissioner's case I was mentioning. Municipal commissioner, and then there are authorities under the land revenue code or the land records, whatever. There are different laws in different states. So if municipal commissioner, while deciding the planning permission, is deciding about the land revenue entries or the mutation entries or land revenue records, the municipal commissioner is not an authority under the land revenue code. So if he's doing something, you can approach the court seeking a writ of prohibition that the commissioner is exceeding his jurisdiction, and therefore he should be prohibited from doing what he is planning to do. So that's the writ of prohibition you seek against an authority who is ex facie manifestly acting without jurisdiction. So that would be a writ of prohibition. Now, in several cases, at show cause notice stage also, you can approach the court. Now, and seek a mandamus, seek a prohibition on the ground that the authority is acting in excess of jurisdiction, lack of jurisdiction, and therefore a writ of prohibition prohibiting that authority from what it is planning to do would be issued. Now, in a given case, there can be all the 3 writs which are rolled up. As I mentioned earlier, authority has already passed an order which is without jurisdiction. So you can ask for a certiorari to quash that order. You can also seek a writ of prohibition against that authority not to proceed with the case because it has no jurisdiction. And you can also seek a writ of mandamus against the appropriate authority to decide your pending case or decide your application, etc. So in a given case, there could be this third writ also which can be issued. So it all depends on what your actual grievance is, against which authority you are agitating your grievance, etc. So this is the third classic writ which is issued by the courts. The fourth writ, which is also issued by the courts, which is not very commonly used writ, which is a writ of Quo Warranto. Quo Warranto's actual literal meaning means show your authority. So for this purpose, there are 2 or 3 requirements. First and foremost, that there is a public office. Now, public office could be civil servant, elected representative, or a constitutional functionary like a High Court judge or a Supreme Court judge, or the Lokayukta, Lokpal, any constitutional functionary, any statutory authority, or any civil servant holding a civil post as defined under Articles 309, 10, 11, etc. So these are all called public offices for the purposes of the writ of Quo Warranto. Or there could be chief minister or a minister who is appointed who is not a member of a legislature, or members of legislatures, that is state legislative assembly, legislative council, Lok Sabha, Rajya Sabha, etc., or the officers of these legislative houses, etc. They all will come in the purview of public office. So that's the first requirement. Second is that office has prescribed qualifications, that to hold that office, you must possess the following qualifications. For example, to become a member of parliament, you need to be of age of 25 years. You need to be citizen of India. Like for president, you need to be age of 35 years, citizen of India, etc. Or for a High Court judge, Supreme Court, there are qualifications prescribed under the Constitution. Or for members of the tribunal, there are large number of tribunals today in the country, like National Green Tribunal, Administrative Tribunal, GST Tribunal. All these tribunals have rules providing for qualifications for chairperson, members, etc. So the second requirement is that there are qualifications prescribed for holding that office. And the third is you can go to court saying that that person possesses no qualification and therefore the court should issue writ of Quo Warranto. Now this writ can be filed at the instance of a person who is either aspiring for that particular post, or it can be in the nature of a public interest litigation saying that so-and-so is occupying the post, he is not qualified to occupy that post, and therefore a writ of Quo Warranto would be issued. So that's the writ of Quo Warranto. Show your authority is the command given by the court to a person who is holding public office. That office has necessary qualifications prescribed under the law, and the person occupying that post is not qualified or does not possess those qualifications. In cases of civil servants, for example, in the engineering department, chief engineer, deputy chief engineer, etc., a person is wrongly promoted to that post, and if there is no other remedy available in a service matter, the person who is claiming to be appointed, claiming right to be appointed to that post, he can seek a writ of Quo Warranto. Or for example, you have seen in several cases, the chief ministers are appointed without being members of the house, and they are required under the law, under the constitution, to become member of either house within a period of 6 months from the date of assuming the office. And if they do not, and they still continue, then there could be a writ of Quo Warranto sought from the High Court. The classic judgment on the writ of Quo Warranto is a 2003 judgment of Supreme Court in case of J. Jayalalitha, Supreme Court judgment of 2003, in which this concept of writ of Quo Warranto has been discussed in detail, and that's the classic judgment to understand the concept of writ of Quo Warranto. The last writ which is issued by the courts is for enforcement of personal liberty of a person or a citizen in the country, that is writ of Habeas Corpus, which basically means a command to produce the body of a person. This can be filed by anybody. Complaining that a person is in illegal detention or illegal custody. Now this custody could be with the police or the state administration. This custody could be with the parents, or in a matrimonial dispute, several times the spouses complain against each other that the child is illegally taken away by someone, by the grandparents or by some other relations, etc. So you will find large number of cases where a writ of habeas corpus is filed even in such cases, matrimonial disputes, complaining about the abduction of a child in a matrimonial dispute. Or there could be cases about the marriages where the complaint is made by the parents about the girl eloping with a boy, complaining that she has been kidnapped and she is in illegal custody of the in-laws or the husband or to-be husband, etc. So these cases also could be subject matter of writ of habeas corpus. But the traditional cases of habeas corpus is, of course, against the state for illegal detention, illegal custody, etc. Now, for writ of habeas corpus, all that you need to complain is that a person is in unlawful custody, illegal custody of some other person against whom a writ could be sought. Now, for this purpose, we need to consider three important articles of the Constitution which guarantee personal liberty, which is Articles 20, 21, and 22. 20, of course, has three basic concepts of criminal law justice, which is no double jeopardy. Then no person can be made to give evidence against himself, and no retrospective criminal law. These are the three basic ingredients of Article 21. And Article 22 authorizes preventive detention. But if a person is taken in preventive detention within specified time, he must be produced before the advisory board constituted under Article 22. And if that person is not produced before advisory board, the advisory board has not confirmed the detention, then in that case, the custody would be illegal and a writ of habeas corpus could be sought. Now, you will find in several cases a writ of habeas corpus being filed challenging the detention order passed under some the preventive detention law. Like, for example, in olden days, we had the MISA, Maintenance of Internal Security Act, or COFEPOSA, or today there is a National Security Act, etc., under which preventive detention is permissible. But if those guidelines are not followed, you can apply for the writ of habeas corpus. Now, that's the most precious writ because it guarantees the personal liberty of persons. Now, as I mentioned earlier, that certain rights under Part 3 are available not only to the citizens of India, but to any person on the territory of India. For example, these three articles which I mentioned, Article 20, 21, 22, they are available to anybody. A person need not be a citizen of this country to enforce these three articles and the rights conferred under that. So therefore, habeas corpus can be filed by anybody. It can be filed by the person, the next friend, or the relation, or it could be filed by anybody on his behalf. The normal rules about res judicata, etc., they do not apply to habeas corpus. You can file the writ of habeas corpus number of times also, of course, unless it becomes a malicious or the frivolous petition, then it will be penalized. But otherwise, in law, there is no bar on filing of the habeas corpus petition multiple times in respect of the same person, because it deals with the personal liberty of a person, and that's the most precious right which is conferred by the Constitution or recognized by the Constitution, because there are several jurists who think that the personal liberty is not a right which is granted by anybody. It exists with a human being who, when he is born. That right is only recognized, and in what manner it can be taken away or infringed by the state is only regulated by the Constitution or by any law. Nobody can confer that right. That right is inborn. It is inherent with a person when he is born. So that's on the concept of personal liberty. So these are the 5 writs which are issued by the courts. Now the next question is, against whom the writs can be issued. For this purpose, we need to understand 2 articles. One is Article 12, which defines concept of state. Now, so generally, a writ could be filed against the state. And Article 12 has defined what is encompassed in state. And broadly, the state includes, as far as union government is concerned, the executive government of the union, the legislature of the union, that is parliament, and parliament includes 2 legislative houses and the 2 heads of those houses, that is the chairperson of Rajya Sabha and speaker of Lok Sabha. So that generally constitutes parliament. That is a state within meaning of Article 12. The executive government, again headed by president, assisted by the Council of Ministers headed by Prime Minister and the bureaucracy. They all constitute the union government. Similarly, at the state level, the state governments as well as the state legislatures are also included in the definition of state. There is also a third concept, that is the local authority, which is included in the definition of state. Now, local authorities before 1993, before the 73rd Amendment, had no constitutional recognition. But traditionally, we have always had three-tier local authorities in rural areas, and in municipal areas, we have municipal corporations and municipal councils, depending on the population of a city. So those are the local authorities who are established for local administration. Post 1993, after 73rd Amendment, there is a constitutional recognition under Chapter 9A, 9 and 9A, municipalities and panchayats. Now, panchayats have three bodies. At village level, it is called village panchayat. At intermediary level, it is called Taluka Panchayat. Of course, the names are different in different states, but broadly, it's Village Panchayat, Taluka Panchayat, and Jilla Parishad. That is the district level. So these are the three authorities at rural areas. They are part of local authority. And at city level, there are municipal councils or municipal corporations depending on the population of that place. So they are the local authorities, and they are included in the definition of state. And there is yet another concept in Article 12, that is any other authority under the control of the governments. Now, this had given rise to large number of litigations from 1950. This definition of other authorities was interpreted by the Supreme Court in what is known in legal interpretation by applying doctrine of ejusdem generis. That is, the words take color from the company they keep. Now, therefore, this concept of other authority was interpreted very narrowly by Supreme Court from 1950 to 1967. And the Supreme Court had said that other authorities must be some species which take color from the other 3-4 authorities which are mentioned. That is the union government, state government, or the local authorities. They cannot be something completely alien to these three bodies in the other authority. So that was traditionally the concept of other authority from 1950 till 67. From 67, Supreme Court started expanding this concept, and in 67, in case of Mohanlal versus Rajasthan State Electricity Board, the Supreme Court held that electricity boards established in the states were state under Article 12. Then next landmark judgment came in 1975, that is Sukhdev Singh versus ONGC, where the ONGC corporation, which was wholly owned and operated by Government of India, was held to be state under Article 12. But the true revolution in the concept of state came in 1978 in the case of very, very celebrated case. I'm sure that no lawyer would be there who has not heard this case. That is Ramana Shetty versus International Airport Authority of India, 1979 Supreme Court. Now, in that case, the Supreme Court laid down the guidelines of deciding which body would answer the description of state. And they broadly laid down 3 or 4 or some criteria. First and foremost, is that authority controlled by the government by way of managerial control or financial control? Then it would be state. Who has held a share capital if it is a company or a entity incorporated? Then third, whether that entity is established under any law, whether that entity is created by transferring a government department. Like, for example, in that case, International Airport Authority was earlier a department of Civil Aviation Ministry, and therefore they held that it is completely a part of the state. And finally, the test of deep and pervasive control. If the government exercises a deep and pervasive control over that authority would be considered as a state under Article 12. So that's the concept of state which the Supreme Court evolved in 1978 in the Ramana Shetty's case. And since then, that concept has been elaborated and liberated to a large extent. For example, in case of Ajay Hasia, 1981 Supreme Court, the Supreme Court said that the private trust, which was running an engineering college, but was receiving government aid was state within the meaning of Article 12. In 1985, the Supreme Court in Central Inland Water Corporation versus Brojanath Ganguly, Supreme Court said that that corporation is a state because it is completely controlled by the union government. So that is how large number of bodies have been held to be state. The last judgment, there are series of judgments, but I'll mention the most important judgment, which is the judgment in case of Zee Telefilms in 2005. Zee Telefilms versus BCCI, that is Board of Control for Cricket in India. Now, in that case, the matter reached to Supreme Court in some curious way. The BCCI had granted tender rights to Star Telefilm and to Zee Telefilms, and Star Television had challenged that in the High Court. And BCCI and Zee Telefilms argued in the High Court that writ is not maintainable against BCCI because BCCI is not a state. That petition went to Supreme Court, and while the matter was pending in Supreme Court, BCCI cancelled Zee Telefilms contract and they said we will go for re-tendering. So then Zee Telefilms filed a petition against BCCI saying that they have wrongly terminated our contract. And Zee Telefilm argued that BCCI is a state under Article 12, and that matter was decided by a bench of 5 judges. By majority, the Supreme Court said that BCCI is not a state within the meaning of Article 12 by applying the tests which I mentioned just now from series of judgments. But Supreme Court said something more, that the BCCI performs a public function, that is organization and administration of cricket in India, which is like a cult in India, the game of cricket, and therefore BCCI is performing public function of organizing and administration of cricket, and therefore, though they are not a state, they are amenable to writ jurisdiction of the High Court under Article 226. So therefore, the writ will not be maintainable against BCCI in the Supreme Court because they are not state under Article 12, but in High Court it would be maintainable because, as I mentioned earlier, under Article 32, Supreme Court can entertain writ petitions only for enforcement of fundamental rights, but the High Courts can entertain the petitions not only for enforcement of fundamental rights, but also for enforcement of public function, public duty, and public interest. And therefore, the court said, applying this public duty, public function test, BCCI would be amenable to writ jurisdiction of the High Court. Now, and that law is still expanding. So that's the concept of state under Article 12 against whom writ is maintainable. There is one other article we must understand, which is Article 13. Article 13 mandates state shall make no law which violates fundamental rights guaranteed under Part 3. So if there is a law made by Parliament or state legislature, which according to you violates any of your rights under Part 3, a writ would be maintainable. And the law is also defined in Article 13, which encompasses not only an act enacted by the Parliament or by state legislature as we normally understand as a law, but it also includes rules, regulations, bylaws, orders, government resolutions, government orders, notifications, everything. So that is within the concept of law. So we have a mandate that states shall make no law which violates Part 3. Law includes rules, regulations, bylaws, notifications, government orders, government resolutions, etc. So if you are aggrieved by a government resolution saying that it is in teeth of your rights guaranteed under Part 3, then you can seek a writ of a writ. You can file a writ in the High Court challenging that particular legislation. Now, while I am mentioning about challenge to a legislation, in a writ petition, you cannot file a writ petition just for declaration that the law is invalid. Now, law, of course, can be declared invalid in our country only on 2 grounds. One is that it is beyond the legislative competence of the legislature which it has made. And second, it is violative of Part 3 of the Constitution. But you cannot just go to court and seek academic relief. That law must have applied to you. By virtue of that law, your other rights must have been infringed, and you must have an independent cause of action. You cannot just go to court and seek mere declaration that the law is invalid, because that would be considered as academic writ or futile writs. And there is a large number of body of judgments of the courts that the courts will not issue a futile or academic writs. Now, That's broadly about against whom the writ would be issued. Now, the next question is, who can file a writ petition? The general answer to that is the Latin phrase, ubi jus ubi remedium, that is, who has a right has a remedy. So the most important aspect of the person who can file the petition, or what is known as a locus to file a petition, is a person who is aggrieved. Now, person aggrieved has a legal definition, a legal connotation, definite legal connotation, which is a person has suffered legal injury. Aggrieved person is not something, in one of the judgments of the Supreme Court, it has been said that aggrieved does not mean that you don't like something and therefore you are aggrieved. You must have suffered legal injury. So that's the test. Now, as all of us, we have studied in our law taught lectures that damage without injury and injury without damage, that is damnum sine injuria and injuria sine damnum. So here there must be a damage with injury. Otherwise, if it is a damage without injury, it is not actionable. It must be a legal injury. Then only you can file a writ petition. That is first aspect. So you must be an aggrieved person. You cannot be a stranger unless, of course, you are filing a public interest litigation, which is where all the rules are relaxed. And you should not be a mere busybody or interloper. So either you are an aggrieved person directly, or you are filing the petition as a public spirited person. In that case, the concept of locus will be expanded and relaxed as far as you are concerned. The most important judgment on this concept of locus, where the Supreme Court has elaborately discussed that, and it still continues to be the valid judgment and a Bible, as I mentioned earlier, is the judgment in case of S.P. Gupta versus Union of India, AIR 81 Supreme Court. Now that judgment is known as first judge's case. There the question about the judges, High Court judges being transferred from one court to another without their consent was in issue. The circular issued by Law Minister was challenged, and the petitions were filed by practicing lawyers, including the president of the including the members of the Bombay Bar Association. And the argument was raised that the lawyers have no locus to question the judges' transfer policy in 1981. The Supreme Court rejected that and expanded the concept of locus standi. And the Supreme Court said that the lawyers, as a part of administration of justice, definitely have locus to question the government's policies relating to appointment, transfer of judges, or confirmation or non-confirmation of the judges as from additional judges to permanent judges, etc. So that's where the concept of locus has been expanded. Then, of course, we have the phase of public interest litigation, which evolved post-1977, that is the post-emergency era. There has been explosion of public interest litigation, and anybody who is espousing the cause as a public-spirited citizen is entertained by the court in public interest litigation. There are, of course, two exceptions. One is that if the respondents demonstrate that the person who has filed a PIL has a private interest, then in that case, he will not be entertained. Or if the person has a personal grudge against some respondent, then also his petition won't be entertained. Or a person is mere interloper or a busybody, then also his petition will not be entertained. So these are the exceptions to the rule of locus standi. Now, insofar as PILs are concerned, there is a judgment of Supreme Court in 2010 in case of state of Uttarakhand versus Balwant Singh Chaufal, in which the Supreme Court has laid down guidelines for entertainment of petitions as public interest litigations. The Supreme Court directed all the high courts to frame rules relating to public interest litigations, and such rules have been framed by all the high courts. Now that's about the locus of a person in filing the writ petition. So that is the concept of locus insofar as writ petitions are concerned. In PILs, as I mentioned earlier, the PIL phase began actually post-emergency era. That is when the new government came post-emergency. The Supreme Court also got liberated, and large number of public interest litigations have been filed since then, and they continue to be filed. And insofar as PILs are concerned, I would categorize the journey of public interest litigation in three phases. From 1977 to 1990, the public interest litigations by the high courts and the Supreme Courts were related to the personal liberty. Like, for example, bonded laborers, inmates in prisons, or the rights of women, or rights of the complaints against the men and women being kept in custody, in the same custody, prison custody, or in prison, the under trials being tortured, or under trials being kept in the jail for more time than their possible sentence, etc. So or bonded labor, etc. These are all rights which were enforced by the Supreme Court in that phase between 77 to 1990. So that's the first phase where the PILs were related to personal liberty. From 90 to 2000, that phase, or 2005, that phase of PIL was in respect of enforcement of environmental laws. Now, environmental laws included the Environment Protection Act, Coastal Regulation Zone insofar as coastal states are concerned, or the forest laws. So these were the laws which were enforced by the Supreme Court and the High Courts in the second phase of the public interest litigation. And the third phase, post-2000, which began, is relating to probity in public life. That is the character of politicians, or the politicians misusing their authority, power, etc. So we'll find large number of PILs post-2005 on that subject. So these are broadly three phases of Supreme Court in Supreme Court and High Courts in respect of public interest litigation. Of course, today PILs are on all the subjects, but I'm broadly classifying these three phases of the PIL litigation, where you will find the most concentrated number of judgments on these three topics. Now, I mentioned earlier about mandamus. In this period, the Supreme Court through PIL has also come out with something called continuing mandamus. Continuing mandamus means the Supreme Court or the High Court issues a mandamus. Mandamus is to do or not to do something, and Supreme Court or High Court did not stop there. They continued to monitor implementation of their orders, and that is known as continuing mandamus. And I will give you two classic illustrations where Supreme Court did that, or three cases. One is the litigation in the name of Indian Council of Enviro Action. That litigation, you will find, if you search the Supreme Court website, you will find hundreds of judgments and orders in this name, because there's not one judgment. There are hundreds of judgments in respect of hundreds of matters that is relating to enforcement of coastal regulation zone notification in all coastal states. Implementation of that notification issued in 91 was not being done, and Supreme Court, through series of orders, directed all coastal states to implement the CRZ notification. The second is Tien Godaverman's case. You will again find hundreds of judgments and orders in name of Tien Godaverman, that is enforcement of Forest Conservation Act of 1980, that you cannot change the forest user without the leave of or prior permission of the central government, and unless you do compensatory afforestation. So that's the second classic case of continuing mandamus. And the third is in case of Jain Hawala case, Jain Diaries case, which are the judgments in the case of Vinit Narayan versus Union of India. There are large number of reported judgments in that name, where Supreme Court monitored the implementation of investigation in that case and the prosecution in that case. Of course, ultimately prosecution resulted in nothing, but that's not the issue. This is where the Supreme Court evolved the concept of continuing mandamus to ensure that the orders which are passed by the courts are completely monitored and taken to its fruition in a logical and proper way. So that's where the PILs and the continuing mandamus have been evolved by the Supreme Court. Now, generally, there are few issues which we must know about limitations on exercise of writ jurisdiction. Now, this is in relation to all the writs. The first and foremost is existence of alternate remedy. So in a draft of a writ petition, you must assert that you have no alternate remedy, or if you have an alternate remedy, you must demonstrate why it is not efficacious remedy. Of course, to this rule of alternate remedy, there are 3 or 4 exceptions. If you demonstrate that the cause of action and the action you are complaining is about violation of your fundamental rights, or there is a violation of natural justice, or that the order is passed without jurisdiction, then the rule of alternate remedy is not applicable. Of course, rule of alternate remedy is not a jurisdictional rule. It is a practice evolved by the courts that they will not entertain writ petition if you have an alternate remedy. That's the first restriction on exercise of writ jurisdiction, of course, evolved by the courts themselves. It's not written in constitution, it's not written in any statute. The second is disputed questions of facts, disputed questions of title. The Supreme Court or High Court will not normally. As I mentioned again, these are all normal rules and there is no bar of a jurisdiction. These are the methods evolved by the court, self-restraint on exercise of jurisdiction. There is a very important classic judgment of Supreme Court written by Justice Tumapal in case of ABL International in 2003, where the court has discussed the concept of disputed questions of facts. Now, in generally, when a petition is filed and respondent files a reply, respondent denies everything what petitioner has said. Now, does that become a disputed question of fact? And the court had said, a petitioner's assertion denied by a respondent does not make it a disputed question of fact. The test is whether the court in a given case can decide the question on the basis of affidavits with reasonable certainty, then it will not be a disputed question of fact. But of course, it entails elaborate evidence, cross-examination of witnesses or proving of documentary evidence, etc. Then of course, the court will not undertake that exercise. But that is how the disputed question of fact has been evolved by the courts and explained by the Supreme Court. Of course, there are several judgments where the courts have entertained the writ petitions and even recorded oral evidence. Very few cases, but that can be done in a given case. The High Court or even Supreme Court has recorded oral evidence in a writ petition, but that's an exceptional case. So as a jurisprudence, it can be done. Generally, it is not done as a self-restraint. Then the matters where there is a scientific expertise involved, or technical expertise involved, or commercial expertise involved, the courts will not exercise the jurisdiction. Or if there is a policy decision, the courts will not substitute their opinion for the policies unless the policy is violative of fundamental rights under Part 3 or policy is contrary to a particular legal provision or a constitutional provision. Otherwise, the courts will not look into the policy and accept the challenge in a writ petition only on the basis that there could be some better policy. That's not what the courts would do in a writ petition. Now that's another one. Then there are other matters like financial decisions, like for example, demonetization of a currency or bearer bonds in 1981. So these are all financial and economic matters and economic policies. The courts have said that this is not the court's expertise or a court's domain, and the court will not entertain petitions challenging such policies. Or there are issues relating to political thicket or political questions. For example, prior to 1993, the questions relating to disqualification of a member, speaker's decision, or chairperson of a Rajya Sabha or legislative council's decisions, etc., the court said these are all political questions. Of course, after Bombay's case, the courts have now evolved that if there is a violation of the provisions of the Constitution, violation of principles of natural justice, then in that, or there is a mala fide action on the part of the speaker, or there is a malice in fact, then in such cases, the courts would entertain the petitions. Otherwise, these are generally known as the political questions or political thicket in which the courts will not entertain the petitions. Now, the next question is where to file the writ petition. Generally, civil lawyers go to section 20 of Civil Procedure Code to find out which court has jurisdiction, where cause of action arises or where the defendants reside or carry on business for gain. So that's the place where under section 20 of CPC, the jurisdiction lies. Insofar as writ courts are concerned, it is the petitioner who is going to the court, who complains that his fundamental rights or statutory rights are affected. So the place where he is aggrieved, the place where he has suffered legal injury is the place where the court will have jurisdiction. So this is something different than the normal civil court jurisdictional concept under section 20. So if you are a resident of Chandigarh and you have received an order of a particular authority and you are aggrieved by that order at Chandigarh, the court at Chandigarh would have jurisdiction to entertain a writ petition. Now there is sub-article 2 in Article 226, which says that even if generally the High Court would exercise jurisdiction over the territories on which it has jurisdiction, which is the state of that particular High Court. But if that authority is situated outside the jurisdiction of the court, that will not prevent the High Court from entertaining a jurisdiction. For example, if a consignment of goods has arrived at a Madras port by a Bombay importer, and he has called those goods at Bombay, the Bombay court would have jurisdiction. Whether it will exercise that jurisdiction or relegate the party to Madras, etc., is another question. But the court at Mumbai will definitely have jurisdiction. The concept is, which is the place where you have suffered legal injury. There are one or two judgments like Majithia's case or ONGC case where the courts have discussed this concept of which court would have territorial jurisdiction to entertain the writ petitions. Now that's broadly about where to file the writ petition. Then generally question arises, is there a period of limitation to file the writ petition? Limitation Act does not apply to writ proceedings. Civil Procedure Code does not apply to writ proceedings. Evidence Act does not apply to writ proceedings. But court generally apply a test that if this cause was to be agitated in a civil court, would civil court entertain a complaint or is it barred by limitation? That is the same test writ court would apply. The writ court applies the test of delay amounting to laches, that is disentitling you for a relief because you have slept over your right for such a long time that third party rights have accrued, vested rights have accrued in favor of third parties. So therefore, that though there is no limitation period, you should not go to the court with delay, which will be constituted as laches. And I can give you an example. In a service matter, you can make representations against the merit list or promotion list. And even if you go after 4 or 5 years also, if there are no accrued rights which have been created in favor of third parties, the court may still entertain a writ petition. But in the case of admissions, like 30th September is the deadline. On that day, admissions close and the academic session begins. So if you go to court on 1st of October, the court would reject your petition even though there is a 1 day's delay. So 1 day's delay could be fatal. In a given case, court can entertain a writ petition even after 4 or 5 years. So that's broadly the concept of the delay, laches, etc. The conduct of petitioner is equally important because, as I mentioned earlier, this is a discretionary relief, and even if you establish your right, court may still not grant the relief to you because court has a wider picture to consider. And courts have always said that we not only see the people who are actually before us, but we see the large number of people who are not before us, who will be affected by an order which we are planning to pass in this writ petition. And considering that general scenario, the court may not grant you relief, and that's why it is a prerogative discretionary writ. So therefore, conduct of the petitioner, approaching the court at the earliest dispatch, approaching the court without suppressing the facts, etc. These are all material factors which you must provide in the petition on which the relief could be denied to you. Now, the last point about the drafting of a petition, as I mentioned earlier, the prayers of a petition must be concise and precise, which is if you are challenging an order, you cannot seek a mandamus to challenge the order. It must be a writ of certiorari. If you want some authority to do something, it is writ of mandamus. If you want authority to prevent the authority from exercising its jurisdiction, it has to be a writ of prohibition, etc. So if the draft of a writ petition is proper, then prayers should be properly drafted. And I would advise the young students and lawyers, one important thing, that you must always, there are forms prescribed for writ petitions by all high courts as well as by Supreme Court. If you have that opening paragraph in which you make out your case, which is what judges immediately read and get the impression of your case about, in which case, if you are able to make out justice of your case, because that is ultimately what the judges are looking at in a particular case, if you make out the justice of your case in the first paragraph and show why you should be entertained and why you should be given a relief, that's where your half the battle in a properly and appropriately drafted writ petition would be. Friends, that's broadly the summary of the law of writs. Now, this is such a vast subject, you cannot cover it in 1 hour, but that's broadly, I think it's a broad overview of the law relating to writs. Thank you so much.
So I can just say that after hearing you, since we are also lawyers for so many years, without even budging for a minute, continuous giving the insights on various prospects. When we had discussed the topic, I just thought that you would be giving a perspective of what are the types of writs and then Article 32, but I never thought that you would be covering a vast spectrum of the insights on different perspectives. Rather, I would say that I am also primarily into the writ side, but certain issues have actually given me a new dimensions of thought process. And more so amongst us, we have Mr. Aseem Pandya, who's a former president of the Gujarat Bar Association. I would just unmute him because he himself is an avid speaker and a lawyer of immense knowledge. And one of his forte is again writ petitions. So I had requested him that since he has been on our platform, he has also been a keynote speaker in the webinars on writs only. So I will ask his insights. And amongst us, we have also Justice S.D. Anand, a former judge of the Punjab Haryana High Court. He has also come on our platform. I'll be unmuting both of them so that we take their insights. Meanwhile, the participants who are watching us on the live on the Facebook, they can post their questions on the Facebook. As well as those who have posted the questions, I would rather say they can post the questions again. Because on the right side on the chat box, I'm only seeing thanks and extraordinary sessions. And they are all going gaga. I'm just reminding of, which I often say and I correlate as a cricket buff, that it is just you assimilate yourself and correlate the feeling what you got when Yuvraj had hit 6 sixes in 6 balls. That feeling, once you hear a session who's an erudite speaker, gives you the knowledge and joy, which can only be cherished for all times to come. So first, I will request Justice S.D. Anand to give his insights. So Justice Anand. Justice Anand, you will have to unmute yourself. S.D. Anand. Aseem Pandya. Because he is also probably on the. Mr. Pandya. Yes, sir. Unmute Mr. Aseem Pandya. Pandya sir, I'm doing it. Yes, sir. Over to you, Mr. Pandya.
Good evening, sir. Dr. Milind Sathe, Justice Alvi. It was, in fact, wonderful and very lucidly you have explained all facets of writ jurisdiction. And therefore, since you are the keynote speaker today, I would not add anything because then it would expand the session unnecessarily. So on a given day, if something more is to be said, I would definitely comment, but it was indeed a wonderful experience of listening to all facets. You covered every aspect, who can be petitioner, who can be respondent, what are the natures of writs. Each writs you have explained in detail with the historical background, even giving the details of 1773 Regulating Act. So all this was amazing. So it would really be a very helpful session, not only for students, but all lawyers. That is my personal view.
Thank you. Thank you.
So I just asked, meanwhile, the questions have started coming. Since Mr. Pandya and Justice Dalvi is there, we will, though, of course, the entire session today, Dr. Milind Sathe is there. But we can always have, they said, in law and otherwise also we say that 2 heads are always better than 1. But though undoubtedly the way that Dr. Milind Sathe came, I'm just reminded what we often also say on the platform. He came, he saw, and he conquered.
Yes.
The way you have conquered the heart, sir. So the first requirement for filing of the issuance of a writ, that the person filing the petition has no other legal remedy available, on what basis then do courts issue a writ of habeas corpus in cases of kidnapping or abduction, keeping in mind that the offences like kidnapping, etc., are already dealt under the IPC.
See, in case of habeas corpus, the complaint is that it is an illegal detention. And illegal detention could be either by the state under any law, as I mentioned, may be preventive detention exceeding the times, or without any charge, without any necessity, a person is detained by the police authorities, or a person is in a private custody. In that cases, even if there is a separate offense of kidnapping under the penal code, which can be taken recourse to, a writ of habeas corpus can still be filed by a person who is complaining that my friend, my relative, or my somebody who is in an illegal custody on illegal detention. It could still be kidnapping also, but the habeas corpus writ could still be maintained.
Because for that, you can ask the person who has asked the question to refer to one important judgment of the Honorable Supreme Court in Mohammad Ikram versus State of UP, which is reported in AIR 1964 page, Supreme Court page 1625, where the question was in what circumstances habeas corpus could be issued to a private individual. It has been said that it is a festinium remedium. So only in clear case, only when party makes out a very clear case, then only habeas corpus would go to a private individual. Otherwise, as Dr. Sathe said, it would be usually to be invoked against the state machinery where there is a complaint of unlawful confinement or illegal detention. So Mohammad Ikram will answer to the persons who had asked the question.
So this is by Dinesh Raj Purohit. He says, what are the basic differences between Article 226 and Section 482 of the CRPC? So it's widening the scope of the session. But
see, Article 226 is an extraordinary constitutional remedy. Section 482 is something like Article 227 insofar as the subordinate criminal courts are concerned. Generally, people club both Article 226, 227 and 482 in one petition because it is superintendence over the subordinate court, which is a criminal court, which is a power under the Criminal Procedure Code under 482. Article 227 is the constitutional power of superintendence over subordinate courts, and 226 is that you say that by this whole exercise undertaken to prosecute you, some rights are violated, and therefore Article 226. So that's how you blend all the three articles and file a petition.
So at your place, they are doing, in our places, very rarely they will allow the entertaining of Articles 226 slashed with 227 and read with Section 482. To the contrary, after that judgment coming, persona designated, etc., they have started saying that you have to create a difference between Article 226 as well as the petition of 227, because then they say then there is a difficulty after that judgment which says that how you will determine that in which cases the LPA would lie and in which case LPA would not lie.
No, you see, in Bombay, there is that problem is all taken care of because there is no LPA in writ petitions anymore. So otherwise,
they go before the revision benches.
I think.
No, even if 220 there in a writ petition, even if the writ petition go before single judge under the rules, but even if it is a single judge, there is no LPA in writ petitions anymore. So all those issues are no more valid.
Okay. Because in our cases where you challenge the virus, etc.,
yes,
then it goes under 226, or right, certain matters like securitization, etc.,
right.
They go in 226. Otherwise, invariably they go to the single bench. But yes, you have an LPA.
That is upon the rules of an individual high court about the distribution of work between single judge and division benches.
Yes, sir. So since we have touched the LPA, we know it. But for the participants, could you just elaborate what is the subtle difference between a writ and a LPA?
The LPA is as latest patent appeals. Now, latest patent was a document issued by the King or Queen of UK. So that is how the concept of latest patent came in, under which the jurisdiction of the High Court was conferred. For example, I told you in 1861, under the Indian High Courts Act of 1861, the three High Courts were established. And then latest patent were issued to those three high courts, which conferred what jurisdiction they would exercise. So in those latest patent, they were original jurisdiction as well as appellate jurisdiction. And that's why those appeals are popularly known as latest patent appeals. Now, though the subsequent high courts were not established under the latest patent, they were granted powers under the latest patent, and that's why there is a latest patent appeal provided in several high courts, though they were not established under the latest patent high court. So latest patent appeal would be an appeal against a single judge's order to the division bench. That is an intra-court appeal. That is broadly the latest patent appeal. For example, if on the basis of valuation, if there is an appeal against the district court, there is a first appeal in the high court. Some high courts provide for second appeal. That would be the latest patent appeal. They may not be second appeal under section 100, but that would be the latest patent appeal. So that is the basically intra-court appeal. So that is completely different from writ petitions. Writ petition is an original remedy against the state or authority against whom a writ is maintained.
So Parveen Selvraj. So why there? I'm doing it in my own words. He says why there is creation of two writs of mandamus and prohibition, since mandamus also includes directions to abstain from doing certain act, whereas prohibition also paramounts in and around that.
No, the basic difference is mandamus is related to public duty or public function. You have a right and somebody else has a duty to do something. So there you ask that person to do something or not to do something. That is mandamus. A prohibition is some person is exercising jurisdiction under a statute or under the particular the charter, etc., which he does not possess, and that's why you seek a prohibition against him from not exercising the jurisdiction which he is purporting to exercise. So that's the difference between mandamus, that forbear from doing something, that mandamus forbearance is relating to his public duty or public function, whereas writ of prohibition is a jurisdiction.
This is by Sunil Bhatia. Can you elaborate the difference between Article 226 and 227 of the Constitution of India for the purposes of writs?
See, as I mentioned earlier, 226 confers original jurisdiction of the High Court's issuance of 5 writs, which we discussed. So that is the original jurisdiction against that writs could be filed against a person who is a state or other authority or who is entrusted with public duty or public function. As against that, a writ, the 227 jurisdiction, which is not basically a writ jurisdiction, but 227 jurisdiction is superintending power of a high court over subordinate judiciary. So if you want to exercise 227 jurisdiction, it is challenging an order of a subordinate court. And generally, the court will not entertain a proceeding under 227 if you have an alternate remedy, like, for example, civil revision application or first appeal or appeal from order. If you have such remedy, the court will not entertain a proceeding under Article 227. So 227 is an extraordinary remedy conferred upon the High Court for correcting jurisdictional or other errors of a subordinate court where there is no other remedy available. So that's the difference. So it is only against the subordinate judiciary, whereas 226 is against the person who are state or authority or the persons who are entrusted with public duty and public function.
So we had tried for unmuting, but Justice S.D. Anand meanwhile has posted on the Facebook. He says a great presentation which would not only be beneficial for the students, but also for the lawyers in the years of practice. That's what Justice S.D. Anand from our High Court has wanted to convey.
Thank you.
So this is by viral. I don't know whether it's his name or this thing. He says, do we have specifically to mention the writ, or we can write any writ as the court may deem, as there are always changes of dismissing of writs? As specifically mentioned, writ does not cover subject matter.
See, you see, the courts are lenient in several cases. So even if you mention a wrong writ, if court thinks that writ must be issued, the court will issue. But as a lawyer, you should be perfect. And therefore, what I am telling you is that you must ask appropriate writ. You must draft a correct writ and ask for an appropriate writ. In a given case, if the court sees injustice, court will, regardless of your errors of drafting and asking a wrong writ, court will still issue an appropriate writ. And that's why you generally say writ of mandamus or any other appropriate writ, order or direction in the nature of mandamus or in the nature of certiorari. But see, we are not, we cannot condone the laxity in drafting. That's why I'm telling you the draft must be proper. Judges may condone that to see the justice in the case, but that's not justification for lawyers.
There are two schools of lawyers. One school of lawyers insist that there should be specific mention of a particular writ. I am of the school which says that we should not demand any particular writ by name, because then you are inviting restrictions pertaining to that particular writ, and more particularly when Article 226 clearly states that High Court shall have power to issue direction. The direction, word direction has been used first. Direction, orders, then comma, reads, include a read in the nature of mandamus, certiorari, etc. So I am of the school, there is nothing wrong. Somebody is entitled to have his views and somebody might insist. But if you go by the bare text of Article 226, in my personal view, I always insist and I always advise students or lawyers that please do not mention any specific writ, because the power is too general. Writ is only a small segment of a very wide power of judicial review. Don't circumscribe your petition by invoking mandamus, because as soon as you seek mandamus, immediately where is the refusal? Where is the demand? All such questions would arise. So that is absolutely my personal view. And there are two types of school, as I said. One school is strictly of the view that it should be prayed by a specific name.
This is by Shiv. What is the difference between a public interest litigation and a normal writ?
Public interest litigation, as I mentioned, is a person who files the petition should not be personally interested. He is filing it on behalf of the persons who are not able to reach the court. It's on behalf of a class of underprivileged or poor people who cannot approach the court. So it's like a class action on behalf of the society to remedy certain wrong which that person perceives. Now, therefore, that Chaupal judgment, Balwant Singh Chaupal judgment, which I mentioned, that has directed the high courts to frame rules. Now, therefore, all the high courts have now framed the rules. So those rules require that a public interest litigant should give an affidavit that he is sponsoring that litigation on his own cost. He is not being funded by anybody. He will undertake to pay the cost if the court finds it frivolous petition, and that he has no personal interest in the matter. If he has a personal interest, he is disqualified to file public interest litigation. So public interest litigation is basically a class action on behalf of the persons who are unable to approach the court on themselves or to espouse a public grievance. It may not be a class action. It can be for espousing a public grievance. But there is one judgment of Justice Pasayat in, I think, Thaure's case, Thaure versus State of Maharashtra, where he has criticized what public interest litigation has become. He has said that it can be like paisa income litigation or publicity involved litigation or political interest litigation, etc. It has ceased to be public interest litigation. So it is on behalf of some society public interest. And one of the judgment has also said, what is public interest? Interest does not mean that you are curious about it or you want to get entertained about that. That is not interest. Interest is where the rights of large number of people are affected or likely to be affected, that needs redressal. So that's public interest.
So in fact, we had one of the webinars where Mr. Aseem Pandya and Justice C.K. Thakur, they discussed only on public interest litigation and public law litigation. And those who have missed it, we have already uploaded on our YouTube channel of Beyond Law CLC. They can watch that, or even they can also go on the Facebook page of our Beyond Law CLC. So this is by Ali. This is an interesting question. He says, not an interesting question, but an insight. He says, could it could be more elaborated on private companies which has a public duty on which writ is maintainable?
See, as I mentioned, Article 226, the writ can be issued not only for enforcement of fundamental rights, but also for any other purpose. Now, in fundamental rights, there are at least 4 articles which can be violated by the private individuals. Like, for example, Article 17, which is abolition of untouchability. Article 18, which is no titles, all titles are abolished. So if you receive a title from a foreign state, the petition can be filed against a private individual. Or Article 23, abolition of child labor, bonded labor. sorry, 23 is bonded labor, 24 is prevention of child labor in factories, etc. So if a private person, factory has employed children, certainly a writ would be maintainable in so far as that cause of action is concerned. Now, as a draftsman, as a lawyer, what you would do is you would basically have the labor officer of that particular region as a party respondent and seek a mandamus against him to ensure that the child labor is prohibited in a particular factory or factory's inspector, etc. So that is how you have to frame a writ petition. But insofar as these 4 rights are concerned, definitely a writ would be maintainable even then the cause of action is against a private individual or the private persons who are discharging public functions. For example, cricket has now been, so if there is a cricket body, private cricket body, the writ would be maintainable in 226, not in the Supreme Court, because it is not a state under Article 12. So there would be cases where a private individual would be amenable to a writ jurisdiction. And the Ajay Hasia's case, which I mentioned, a private body, of course, it was receiving government aid. It was running engineering colleges, but it was receiving government aid. And that's why it was actually held to be state. But technically and jurisprudentially, a writ would be possible against a private individual also.
So we can take cue from that Anandi Mukta also.
Yes, that is bonded labor.
Yes. Where if you're performing a public duty, then...
Anandi Mukta's case, AIR 1989 probably. Supreme Court.
This is by Dr. Amrita. He said in the direction disposing the writ by the Tripura High Court, has directed the appellate authority, a private university, to dispose of the appeal in a time-bound manner. However, they have decided the appeal without considering the writ petition. Can the petitioner file a contempt petition before the Tripura High Court?
No, sorry, I didn't get your question.
So this is in a direction, this is by Dr. Amrita, in a direction disposing of the writ petition, the Tripura High Court has directed the appellate authority, that is, private state university, to dispose of the appeal of the writ petitioner, considering the writ petition as part of the appeal. But the appellate authority did not decide the appeal while deciding the appeal. Can a contempt be filed in this regard?
Not decided, of course you can file a contempt petition.
No, sir, he says that particular part has not been dealt. He says there is an order.
So you are saying appeal is decided, but it has not been decided as per directed by the High Court.
No, he says it's, in fact, it's a twofold question. He says, like, assume he files a appeal, but the court, while disposing of the directions to decide the appeal, says that the averments made in the writ petition should also be constituted as a part of the appeal. But that writ petition is not dealt with.
No, that's very difficult. See, it may not amount to contempt because you see the points raised in the petition would have been dealt with in the order. If see the appeal is not decided, there would be contempt. But if appeal is decided in a particular way, now whether the particular point from a writ petition is dealt in a manner which you desired it to be dealt, that will not amount to contempt.
I will just buttress that for the contempt, they would always say that willful, intentional, knowingful, and deliberate ingredients have to be spelled out for the purposes of contempt. So this is by Devika Raj. Perchance she's in my office only. So in the beginning of the session, you mentioned that it is the prerogative / discretion of the court to issue the writ in case any of the fundamental rights guaranteed by the Constitution are infringed. In this case also, will it be the discretion of the bench or not?
In which case?
In the beginning of session, in case
I mentioned that issuance of a writ under Article 226 or 32 is a discretionary remedy. And as I mentioned earlier, that even if you establish your right that what your complaint is correct in a given case, the court may still not issue a writ because the court possibly would think that not issuing a writ in your favor would be doing more appropriate justice than issuing you writ, which you have sought for. So that is why I said it's a discretionary and prerogative writ that even if you establish your right, the court may not issue the writ. I'm not saying court will not, court may not. The court has that discretion because court sees larger picture.
So this is by Advocate Shajan. Is it possible to pray for a writ of execution of a decree evicting large number of encroachers from the site? The said decree had been appealed in the writ court and also the Supreme Court. The question is because police and the political interference has become unimaginable.
Answer generally is no. If you have a decree, you must execute it in a known process under the Civil Procedure Code for execution of a decree. That's a general answer. But if you have some extraordinary circumstances which give rise to some public issue, suppose, for example, there is a road widening and there are encroachers on that road, and there is a decree and that decree is not being executed for some political or vested interest, etc., then there can be a public interest litigation that the decree is not, but for execution of a decree per se, you cannot approach the writ court. But if there are some public issues, etc., then possibly you can go to court and ask for the reliefs.
So 2-3 lawyers have asked, or the participants as such have asked. They say that since the writ lies under the High Court also as well as on the Supreme Court, so what is the best way to approach, whether directly to the writ or in a High Court or an apex court, which would be better and useful?
See, as I mentioned, the difference between Article 32 and 226 is Article 32 is a fundamental right itself, and it is for enforcement of fundamental rights under Part 3. Whereas the High Court's jurisdiction under Article 226 is not only for enforcement of fundamental rights under Part 3, but for any other purpose. Now that any other purpose has been so widely interpreted, public duty, public function, public interest, public character, it could include anything. So therefore, High Court's jurisdiction is much wider. Now, as a matter of practice, 99% of the cases, if you approach the Supreme Court directly under Article 32 petition, Supreme Court would send you to the parent High Court, where you should file the writ petition. Of course, that's not a bar on jurisdiction. That is the exercise of discretion. So therefore, Supreme Court generally says in 99% cases that you approach the territorial High Court.
So we have unmuted because the participant who posted the question of Tripura High Court, he says that probably the question has not been put forth in the right manner. We have unmuted a doctor. She can ask the question. He or she can ask the question directly. Dr. Amrita.
Thank you. Thank you. Can you hear me, sir?
Yes.
Yes, sir. Actually, what happened for filing an RTI, I have been terminated by a private university in Tripura in 2012. So I have filed a writ petition, and in that writ petition, because my termination happened in the month of February, on 14th February 2012, and I have filed an appeal before the appellate board of the university, but that appellate board did not act. So I approached my lawyer. My lawyer said, who was a senior lawyer before Tripura High Court, then it was the Guwahati bench in 2012. So he said, you have to wait. We cannot file the writ petition now. You send a legal notice. So I have sent a legal notice, and I waited from February to April. And in the month of April 2012, on 24th of April, there was a first hearing. And in that hearing, the university lawyer played before the court that since an appeal is pending before the alternative, that is the alternative remedies available with the appellate board, so the court should direct the petitioner to exhaust the alternative remedy before the appellate board, that is the appellate authority. So High Court directed the appellate authority of the Tripura University of Tripura to dispose of my writ petition, dispose of my appeal, which is filed before the appellate authority, and making the writ petition as part of that. Making the writ petition as part of the appeal. But the appellate authority decided the appeal, but without considering the writ petition as part of the appeal as directed by the High Court. Okay, I remained jobless for 4 months, and I was not able to pursue the matter because another alternative remedy was available before the governor, which I am pursuing. So I am asking that as the appellate authority decided my appeal without considering the writ petition as my as a part of the appeal, so can I file the contempt petition now because it is more than 8 years?
No, all right. See, when High Court says that the appellate authority shall decide the appeal, taking into consideration what is stated in the writ petition, does not necessarily mean that the appellate authority must deal with everything what is stated in the writ petition. the points in the writ petition are required to be considered. And I'm it is somebody's perception that they are considered or not considered. See, if the appeal was not decided, there could have been a contempt. But the appeal is decided and there is a judgment written. Now that judgment would have considered all your grievances in the appeal. The writ petition would have been an additional material. If there is something on which the decision may change, which is not considered, which was part of a writ petition, then possibly you can apply, or you can file a contempt. But you will have a serious problem because it is an issue of perception. Whether that point is considered in a way satisfactory to you or not is a very difficult thing to establish. Unless there is a specific point which was there in the High Court, which was not in the original appeal memo, and that point has not been considered, then possibly you may have a case. But insofar as contempt is concerned, there is a limitation of 1 year. So whether you are within limitation or not, you need to consider that.
Thank you. As we had discussed that the session should be around for 1.5 to 1 hour 45 minutes. But the way the time actually flew, one never realized, and especially once it is in a good company. And when it's more insightful, one only feels that one should continue hearing it. It's more, and once the session is so enlightening and coming forth, it's just like good music ringing into the ears and the heart, which would always be, as I said, cherished by everyone. And in fact, we have been holding so many webinars. It's one of the rare occasions where, not a rare occasion, but an occasion where we have got so many text messages that to the effect that the session was really enlightening, not only for the students of law, but also the lawyers. But I will only buttress that fact, as we say that student of law, invariably we think that who is studying in law, but as a lawyer and as a judge, we always invariably ourselves also connect as a student of law. And the fact that we are all student of law is also, I will only buttress my submission to the effect that when Justice Roshan Dalvi is there and just Mr. Aseem Pandya is there and Justice S.D. Anand is there, they only give us that stimulating feeling that irrespective of your age, irrespective of the knowledge what you have, you should also have that feeling to improve your knowledge. And that is why they gave us that feeling of the platform that if you have to reach on that pedestal of level, then you have to continue the pursuit to learn the knowledge. And the participants, the way they join the platform, not only on the Zoom itself or on the Facebook, shows that people during this lockdown are willing to learn. Those who want to connect with us, we have already posted on the WhatsApp group that our mobile number and Facebook page, as well as Instagram, as well as the YouTube channel of Beyond Law CLC. This webinar would also be uploaded there. Tomorrow, we have in our pursuit to continue with the sessions, we have tomorrow another speaker who has been received whenever he has come on this platform for his immense knowledge. We have tomorrow N. Manokaran. He would be giving us the insights, the overall view and way forward in the Land Acquisition Act. So do stay connected with us for the webinar. And day after, we will be having on cyber law. And before we leave for the day today, I will request Mr. Pandya to say a few words, and then Justice Roshan Dalvi. And we are all actually from the team of Beyond Law CLC are indebted for connecting us to a person who has given an insights and a thought-provoking session for the immense knowledge Mr. Sathe has dissipated. In 1 hour, it was treat for the heart, ears, and whatever you can say. Over to you, Mr. Pandya, and then we will.
Justice Dalvi first.
Yes.
Honorable Judge should be first, yes.
This was a complete lecture. But for persons who are listening today, I might say that when you come across, there's people saying that there is corruption and the public officer does not function or any such thing, I don't know why you don't take into consideration your right of a writ and call upon that public officer who has not functioned to function. The second thing is that when people talk about writs and about fundamental rights, we all the time hear about Article 14, 15, 19, 21, etc. But we don't hear about Article 23 so far as it relates to trafficking of women and children. Now, Dr. Milind Sathe said that there are 4 articles where you can file writs against private individuals. And just because, despite the grossest violation of human rights, those persons cannot take up cudgels, nobody else does for them. That is one article. If you read in any of the constitution books, you will find Article 21 going into some 100 pages, but Article 23 going into 1 paragraph. Because they don't have any capacity to fight. And when there is public interest litigation, this would be a very raw and a right subject for people like Milind Sathe to take up for the cause of that humanity.
Mr. Pandya.
Yes, as I already said, it was absolutely stunning lecture. I enjoyed thoroughly, and I congratulate Dr. Sathe for giving such a good insight to all the persons who are concerned and who attended this webinar. And I congratulate Mr. Vikas for holding this kind of webinars which disseminates knowledge and that helps the legal profession and law students of the country. So thank you very much for inviting me here.
No, sir, at least everybody is welcome, and the persons who are giving insights to us only gives us a belief, and especially then thereafter they introduce to another speaker, that only gives us a belief and a self-confidence to the effect that whatever pursuit we had taken up during these lockdown times is at least being well received by the participants as well as the speakers. That only gives us another mindset that sometimes you feel that doing more than 100 webinars, today was our 102nd webinar, to stand corrected. Mr. Pandey, yours was the 100th one. So we stand corrected, but doing 100 webinars, sometimes it does take a toll. But the spirit with which people are actually being connected with us, then it says that we should do more. I'm just reminded of that ad, ye dil mange more to kyun na kare aur. Everyone stay connected, stay blessed. And again, Dr. Milind Sathe, you are the master of the show today. Thank you, the way you have given us the insightful session. And thank you for Justice Roshan Dalvi for making us connected, Mr. Seen Pandya, as usual, for his insights, and Justice S.D. Anand. I'm just telling the names, but needless to add, those participants who are watching us on the Facebook as well as on the this platform, we are also indebted to them because it is their kick to help us to do us better. That's the way to move forward. Thank you, everyone. Stay safe, stay healthy. Thank you.
Thank you.